Good day to all. Today we are going to see the subject called company law. In that company law, we are going to see an important topic called Memorandum and Articles of Association. So this is a syllabus. In this syllabus, we have unit number 2. In unit number 2, the two important topics, Memorandum and Articles of Association, is being discussed here. So let us see what are those memorandum and articles. So the formation of a public company involves preparation and filing of several essential documents. So one is Memorandum of Association, the other one is Articles of Association. The preparation of Memorandum of Association is the first step in the formation of a company. It is considered to be one of the important documents which defines its objects and lays down the fundamental conditions upon which alone the company is allowed to be formed. So, memorandum stands as a base to form of the company. It is a charter of the company. It governs the relationship of the company with the outside world and define the scope of its activities. So let us see what are the documents involved into the contents of Memorandum of Association. The first one is the name clause, registered office clause, object clause, capital clause, liability clause, association or subscription clause. So let us see in detail each type of clause. So the first one is the name clause. Name clause insists the company's name, how the company name should be. These clause is being mentioned in the Companies Act of 1956. The promoters of the company have to make an application to the Registrar of Companies for the availability of name. So first they need to check out there should not be any duplication of the name. It means anyone should not have the same company to be exist before. The company can adopt any name if there is no other company registered under the name. For example, Reliance India Limited, it's only the one owner. So no one has a claim to take up the name of the company. The name should not be considered undesirable and prohibited by the central government. It is mentioned under section 20. It means it should not go against the law of the government. The name which misrepresents the public is prohibited by the government under the emblems and names. So the emblems and names also should govern by the Government of India under the Prevention of Improper Use Act of 1950. So coming to the Registered Office Clause. So what is this Registered Office Clause? Next is the Object Clause. This is the most important clause in the memorandum because it not only shows the object or objects for which the company is formed, but also determines the extent of the powers which the company can exercise in order to achieve the object or objects. So it mentions the motive for what the company is being formed and the powers required by the company. It is essential that the public who purchase its shares should know clearly what are the objects for which they are paying. So the public should be aware of for which company they are going to invest it, and in turn company is moving towards what kind of objectives. The next comes the capital clause. Memorandum shall also state the amount of share capital with which the company is to be registered and division thereof into shares of a fixed amount. The capital with which the company is registered is called the authorized or nominal share capital. The nominal capital is divided into classes of shares and their values are mentioned in the clause. There is something called authorized share capital. What does it mean by authorized share capital? If, for example, a company aims to get 10 crores as the capital, that is considered to be their authorized share capital. It is, for the namesake, it will be mentioned as 10 crores. But the actual capital, whatever is needed by the company, is named as the share capital. The nominal capital is divided into classes of shares and their values are mentioned in the clause. The amount of nominal or authorized capital of the company would be normally that which shall be required for the attainment of the main objects of the company. Though the company may need 10 crores as authorized share capital, but at present the company may need only 8 crores. So the promoters of the company always take steps to get the 8 crores in order to start the company. So these details has to be mentioned in the capital clause which comes under the Memorandum of Association. The next is the Liability Clause. In the case of a company limited by shares or by guarantee, Memorandum of Association must have a clause to the effect that the liability of the members is limited. It implies that a shareholder cannot be called upon to pay any time amount more than the unpaid portion on the shares held by him. He will no more be liable if once he has paid the full nominal value of the share. So here again there talks about the liability of the shareholders. For example, if a shareholder is liable to pay 10 rupees per share, the company can get only 10 rupees per share from that particular shareholder. The company is not liable to get more than the amount mentioned for per share. So this 10 rupees will not be called in one single call, but it will be called in 2 to 3 times. The first time will be collected and as the initial amount of the share. For example, if the share cost around 10 rupees, initially it will charge only 4 rupees. So only 4 rupees will be collected from the shareholders. And after a period of time, then they'll collect the remaining amount. The second call will be for 2 rupees. Then it comes to 6 rupees. Then again they'll call for another 2 rupees. So it goes on till they attained the actual value of the share. Association or the subscription clause. In this clause, the subscribers declare that they desire to be formed into a company and agree to take shares stated against their names. No subscriber will take less than 1 share. The memorandum has to be subscribed to by at least 7 persons in case of a public company and by at least 2 persons in case of a private company. The signature of each subscriber must be attested by at least one witness who cannot be any of the subscribers. Each subscriber and his witness shall add his address, description and occupation if any. After registration, no subscriber to the memorandum can withdraw his subscription on any ground. So once the subscription is paid by the subscriber, there is no point of refund. The subscribers can declare that they desire to be formed into a company and agree to take shares stated against their names. Though I am interested to buy 100 shares of that particular company, The company is also have a right to provide only certain particular number of shares. For example, if I apply for 100 shares from the company may allot me only 80 shares. It depends upon the allotment of shares, policies and procedures followed by the company. So as per the policy, only 80 shares will be allotted to me. So this is called subscription clause. So while subscribing for the shares, the subscriber has to mention his name, address, occupation and the other documents required to purchase the share. As soon as he purchases the share, he becomes the shareholder. From the subscriber, he becomes the shareholder. Now we'll go to the next topic, Articles of Association. Every company is required to file Articles of Association along with the Memorandum of Association with the registrar at the time of its registration. So both the public and the private company has to submit the Memorandum of Association document as well as Articles of Association document to the registrar as per the Companies Act of 1956. There were a lot of amendment has been taken place. The latest version, the latest amendment which had taken place is Indian Companies Act of 2013. The Companies Act defines articles as articles of association of a company as originally framed or as altered from time to time in pursuance of any previous Companies Act. So depending upon the situation, the environment as well as the act the government requires, the act also goes under certain changes. The Articles of Association are the rules, regulations and bylaws for governing the internal affairs of the company. The very important point, Articles of Association deals with the internal affairs of the company. Memorandum of Association deals with the external affairs of the company. So any document which is dealing with the company by the external person, those document comes under memorandum, and the rules and regulations, the policies, the procedures which has been followed within the company comes under the internal affairs of the company. They may be described as the internal regulations of the company, governing its management and embodying the powers of the directors and officers of the company as well as the powers of the shareholders. They lay down the mode and manner in which the business of the company is to be conducted. The A to Z activities of the company, especially the internal activities, will be mentioned. Their recruitment policies, their internal dealings, their culture, their organization development, their strategies, everything will be followed based on the Articles of the Association. The powers of the directors, managing directors, the powers of the shareholders, debenture holders, the limits of the creditors, everything will be mentioned in the internal affairs of the company, which is shortly we call it as Articles of Association. Next, we'll see what are the contents here in Articles of Association. Before we saw Memorandum of Association, name clause, registered clause, association or subscription clause. The same way, the articles also has a numerous number of points to be seen. Articles generally contain provisions relating to the following matters: the exclusion, whole or in part share capital, different classes of shareholders, and variations of these rights. execution or adoption of preliminary agreements, if any. Allotment of shares, that is shares allotted to the public. As I told you earlier, if I opt for 100 shares, the company has right to allot 180 shares. It depends upon their procedures. And lien on shares, calls on shares. Calls on shares is the first call, second call. So first they may call for the 4 rupees per share, which is entitled to be 10 rupees per share. Then they go for the remaining amount. So that is called first call, second call, third call. Usually the company will end up with the second call. Forfeiture of share. Forfeiture of share is nothing but the cancellation of the share. So cancellation of the shares. What does mean by cancellation of the shares? If the shareholder applies for a share, the company has full rights to cancel it. To cancel all the shares of that particular shareholder. It depends upon the meetings and the regulations, the policies which is followed in the internal affairs of the company. Issue of share certificate. So, how to issue the share certificate, for whom to issue, the process comes in when one person would have bought only 10 shares, the other person would have bought only 100 shares. So there are vast difference between one person to the other. For example, A would have bought 10 shares and B would have bought 100 shares. So how to issue share certificate to these kinds of shareholders? Issue of share warrant, transfer of shares. In case I am not interested to have the shares of that particular company, I would like to sell the shares, transfer the ownership of the share. Yes, that can be done. The procedures to be followed into that. The transmission of the shares. Alteration of the share capital. As I told you before, the authorized share capital is 10 crore, but I am ready to start my company with 8 crore and if I would like to reduce my share capital to 7 crore, I can do it. That is called alteration of share capital. This all decisions will be taken by the board of directors. Borrowing power of the company. The borrowing power is the amount of loan advances taken by the company in the way of loans, in the way of advances, in the way of debentures, creditors, etc. Rules regarding meeting. So, yearly meeting has to be held with the required period of time. For example, the meeting with the shareholders, the board of directors meeting, and the annual general meeting. So the periodical meeting for these meetings should be mentioned clearly. Voting rights of the members. Voting rights in order to select the board of directors members, the managing director, and the other positions in the company. So who are those members who will be voting for this? The shareholders have full rights to give the vote and notice to the members. For the other members, if in case of any activities made by the members against the policies of the company, then the notice has to be issued from the company side. Dividends and reserves. Dividends is the interest paid to the share capital. So dividend will be given to the shareholders. Accounts and audit. Arbitration and provision. Directors, their appointment and remuneration. The appointment and the reappointment of managing director, manager and secretary. Fixing limits of the number of directors. So each company will decide how many directors to be there in the board of meeting. It again, they have to follow the rules mentioned in the Companies Act of 1956. Payment of interest out of capital. Interest to the creditors, interest to the shareholders, interest to the debenture holders. Common seal, yes, company is an artificial person. Though it is an artificial person, it should have a common seal. It cannot sign by its own, but its signature will be revealed in the place of a common seal. Next is the winding up. Winding up is the closure of the company. So there are certain procedures again to be followed for winding up. In winding up, we have two types. One is voluntary winding up, one is creditors winding up. So it depends upon the situation, upon the activities of the company, winding will take place. Now see what is the distinction between the articles and the memorandum. Memorandum of Association is charter of company indicating nature of business and capital. It also defines the company's relationship with outside world. I told you, external affairs of the company. Articles of association are the regulations for the internal management of the company and are the subsidiary to the memorandum. So, memorandum and articles are the two important documents to run up the company. So, any documents which has to be mentioned within the internal affairs, that has to be covered up in the articles of association. So, these two documents has to be prepared and submitted to the registrar of the company. After getting approval, then only the public limited company as well as the private limited company can start up the business. Public limited company, after submitting memorandum and articles of association, then they go for subscription of capital. Subscription of capital, it means inviting the public to subscribe its shares. But in case of a private limited company, it can, as soon as it gets a memorandum and the articles of association registered from the registrar of the company, then they can start up the business. They no need to wait for the other documents. Every company must have its own memorandum. A company limited by shares need not have articles of its own. Limited by shares, since the company limited by shares, the private limited company, need not have its articles of its own. Any act of the company which is ultra vires, the memorandum is wholly void and cannot be ratified even by the whole body of the shareholders. So, memorandum is considered to be very, very important. It deals with the kind of a business, the kind of a relationship with the franchisees, with the customers, with the agents, with the suppliers. So, any activities dealing with the other portions or other parties of the company, those has to be mentioned in the Memorandum of Association. These two documents are very important. When you go for any public and private limited company, these two documents has to be registered. And it's subject to title, it goes under changes. There are a lot of amendment has been taken place in the year 2000, in the year 2004, and the latest amendment has taken place in the year 2013. Any act of the company which is ultra vires, the articles can be confirmed by the shareholders. If it is intra vires, the memorandum. Memorandum of Association is the charter of company, is a supreme document. Articles of Association are the subordinate to the memorandum. So from this point, we come to know Memorandum of Association is considered to be the very most important document in the Companies Act. So it is considered to be the supreme document. Any internal affairs or internal business can go for a change. It doesn't going to affect the third party. It will not affect the customers. But the Memorandum of Association is the charter of the company. Is a supreme document, very important document, are subordinate to the memorandum. In all kinds of companies which comes under the Indian Act, both public company as well as private limited company, both has to go under the changes of the Companies Act of 1956. The Memorandum of Association and the Articles of Association has a very important role to be played in the Companies Act of 1956. All companies has to go under. An audit will also take place from the Companies Act. The registrar with a team may come at any point of time for the internal audit. What does that internal audit mean? Internal audit means that the rules which is mentioned in the Memorandum of Association and the Articles of Association, both has to be mentioned. So the rules mentioned in these two documents has to be followed in the current. If they don't follow it, they have to see to it that they follow it. And the important points which is not followed, it will go under penalty with the fine of charges. In this case, the directors is not liable for any other changes which is happening in the company. It is wholly responsible of the board of directors. Board of directors jointly together, they form and they take up the important decisions in the company. Each decision taken by the board of directors will have to abide by the rules of the government. The board of directors is not necessary they have to follow only the Companies Act, but they have to follow the other rules mentioned or forced by the Government of India. For example, Environment Protection Act. Any business, any factory, any production which is run by the company has to follow the rules. The Environmental Protection Act is very important to run up the business. They have to get a certificate from the company in order to ensure that the business runs in a smooth way. If any illegal activities or illegal kind of business which is being taken place by the government, by the company, the government has all rights to take up the legal action against the companies. This legal action can be taken for both public company as well as for the private limited company. So in this session, we have seen detailedly about the memorandum and the articles of association. So you all have come to know the importance of these two documents. In the upcoming sessions, we'll see more detailedly about how far these two documents are important in the other activities and other affairs of the company, and how these two documents are supporting the other activities and the affairs of the company. So this Companies Act will go under amendment as per the requirement by the Ministry of Corporate Affairs. And that's all with the sessions. Thank you for patiently listening to me. Thank you.